Hi, I'm Lorna Johnston, the Executive Director of the Standards Commission. This short video aims to outline what you can expect at a Standards Commission hearing if you are the Respondent Councillor or Board Member. The parties involved in the hearing are firstly the hearing panel, which comprises of 3 members of the Standards Commission. After listening to evidence and submissions, the panel will make a decision on whether you've breached your code of conduct, and if so, on the sanction to be imposed. Secondly, the Ethical Standards Commissioner, known as the ESC, or their representative. As you will be aware, it was the ESC's responsibility to investigate the complaint alleging that you breached the code. At the hearing, the ESC will present the findings of the investigation and their conclusions as to whether or not you have breached the code. Thirdly, you or anyone you have appointed to represent you. And lastly, any witnesses. That's anyone called by the ESC or you, or required to appear by the hearing panel to give evidence about what they witnessed. So that's what they saw, heard, or understood to have happened in respect of the incident or incidents that are the subject of the issue or issues to be considered by the panel at the hearing. You're entitled to attend the hearing, to give evidence, and make submissions on whether or not you have breached your code. The hearing is your opportunity to provide your recollection of events and to lead any witnesses so they can provide their recollection of events, to make submissions on whether you breached the code, and to make submissions in mitigation and on the sanction that should be imposed if a breach is found. It is common for respondents to represent themselves at hearings. The Standards Commission understands that being the subject of a hearing can be daunting, particularly for respondents who are not represented. We have therefore prepared guidance for unrepresented respondents, which, along with this video, is intended to assist you in understanding the format of the hearing and how it will be conducted. The guidance can be found on the Information for Respondents page of the Standards Commission's website. If, on receipt of a referral report from the ESC, the Standards Commission decides to hold a hearing about your conduct, we will write to you within 5 working days to advise you of the date, time, and venue for the hearing, including whether it will be in person or online. Hearings are normally held between 6 and 12 weeks after the date on which the Standards Commission decides to hold a hearing. We will also provide the names of the hearing panel. Hearings are conducted by a hearing panel comprising of 3 members of the Standards Commission, with 1 member acting as chair. And finally, we will outline the information that we need you to provide. So the information that you're required to provide. Having been advised by the Standards Commission that we are to hold a hearing into your alleged conduct, you're required within 21 days of the date of the notification of the hearing to complete and return an information template noting, firstly, whether you accept the facts in the ESC's report, and if not, which facts are in dispute. Secondly, whether you accept any or all of the conclusions reached by the ESC. Thirdly, whether you intend to attend the hearing, give evidence, and/or be represented or supported. Fourthly, the names and contact details of any witnesses you propose to call to give evidence on your behalf, along with a brief summary of the nature of their evidence and confirmation that they have been contacted and are able and willing to attend the hearing. And lastly, whether you want the Standards Commission to require any individual to give evidence and/or to produce documents, and if so, why. If the hearing is to be held online, you're also required to provide the Standards Commission with the contact details for any witness you propose to call, so that we can send them information about how the hearing will be conducted and a joining link. The Standards Commission publishes information about upcoming hearings on its website. Hearings are usually held in public, meaning members of the press are entitled to attend a hearing that is held in person or to view the live stream of any hearing held online. The Standards Commission also issues and publishes press releases and written decisions outlining the findings made at hearings. As such, should you wish to do so, you're entitled to respond if approached by the media either before or after a hearing. As always, you should be careful to ensure you comply with the code when interacting with the media. You can contact the Standards Commission at any time if you have any questions or concerns about the hearing process or what's expected of you. If you need assistance to give evidence or make submissions because of any physical or mental impairment, language difficulty, or any other substantial reason, you should contact the Standards Commission staff accordingly, at least 14 days before the hearing, so that we can put appropriate support measures in place prior to the hearing, as far as is reasonably practical. The productions are any documents submitted by you or the ESC that are to be considered by the hearing panel, both in advance of and at the hearing. These include a copy of the ESC's report. Any productions, including any case law that you wish to rely on at the hearing, must be submitted to the Standards Commission at least 14 days before the hearing is scheduled to commence. The relevant paragraphs in any case law must be highlighted. The Standards Commission will add to the productions any documents or case law that you or the ESC submit, and will circulate numbered copies to both parties at the earliest available opportunity. Both you and the ESC can refer the hearing panel to any document in the productions during the hearing and can take the panel through any points you consider to be relevant. The hearing panel may decide not to accept any productions submitted at least 7 days before a hearing if it considers it would be unfair to less than 7 days before a hearing if it considers it would be unfair to the other party to do so. As previously noted, the Standards Commission has a dedicated page on its website for respondents. This page contains information about what a respondent is required to provide before the hearing and how to access the respondent's information template. It contains information about what happens when you are and are not to be represented at a hearing, and if you decide not to appear or to be represented at the hearing. It contains information about the order of proceedings to be followed at a hearing, and also a copy of the Standards Commission's hearing rules, which outline the procedures to be followed. The page also outlines the sanctions available to a hearing panel. It should be noted that if the hearing panel finds, on the balance of probabilities, that you have breached the code, as alleged, it will be obliged to impose a sanction. The sanctions available to the hearing panel are censure, suspension, and disqualification. A policy outlining the factors the hearing panel will consider when making a decision on the sanction to be imposed can be found in the application of sanctions policy, which can be downloaded from the table at the bottom of the page. You will be invited to attend a pre-hearing meeting. The Standards Commission holds pre-hearing meetings to try to resolve any procedural issues and to give the parties the opportunity to raise any issues and ask any questions before the hearing itself. The chair of the hearing panel will chair the pre-hearing meeting, and a member of Standards Commission staff will normally also be in attendance. Pre-hearing meetings are held online and usually take 30 to 45 minutes. At the pre-hearing meeting, the chair will check you are aware of the procedures to be followed at the hearing and will give you the opportunity to ask any questions or raise any issues you may have about this. The chair will then ask both you and the ESC to confirm who you will be calling to give evidence as a witness and that those individuals have agreed to appear, whether you intend to submit any further documentary evidence or case law to be added to the productions, and how much time you or your representative will need to present your case at the hearing. So if the hearing is to be held in person, when you arrive at reception, you should ask for a Standards Commission staff member who will direct you to the hearing room and check whether you have any questions before the hearing starts. The Standards Commission may decide to hold the hearing online and live stream it, for example in cases where it appears there is little dispute between the parties and a limited number of witnesses other than the respondent are to be called. If the hearing is to be held online, the Standards Commission will contact you to send you information about how the hearing will be conducted, including a guidance note on using the Zoom platform and a joining link. If the hearing is to be held online, you will be admitted from the waiting room so that Standards Commission staff can check your connectivity, resolve any technical issues, and answer any queries you may have. You will then be placed in a breakout room until the hearing starts, at which point you will be admitted to the main meeting. A diagram showing how the hearing room will be set up if it is to be held in person can be downloaded from the table at the bottom of the Information for Respondents page on the website. Members of the public and press can attend and sit at the back of the room as observers only. So, in terms of the order of proceedings, the hearing chair will open the hearing by introducing the members of the hearing panel, the parties, and any Standards Commission staff in attendance. The chair will then outline the complaint under consideration and explain the procedures that will be followed. The chair will also ask you and the ESC or your representatives to confirm the name and order of witnesses to be called. The chair will then ask you and the ESC whether you have any questions about how the hearing will be conducted. The chair will adjourn the hearing at various points to allow for comfort breaks and for the panel to deliberate. If you need any additional comfort breaks or time to gather your thoughts, you should let the chair or a member of Standards Commission staff know. Once any questions on the process have been answered, the chair will ask the ESC or their representative to make introductory remarks and to then call their witnesses. I'll provide information on how witnesses are questioned on the next slide. When any witnesses called by the ESC have completed their evidence, the chair will ask you or your representative to make any introductory remarks and to call any witnesses who have agreed to give evidence on your behalf. When your witnesses have completed their evidence, the chair will invite both parties, starting with the ESC or their representative, to make submissions as to whether there has been a breach of the code. The panel may put questions to either party at any time. The chair will then invite both parties to make any additional points they wish to make in light of questions from the panel. After hearing the submissions, the hearing panel will adjourn and determine whether, on the balance of probabilities, you have breached the code. The panel will then return and announce its decision in public. If it decides you have not breached the code, the hearing will conclude at that point. If the panel decides you have breached the code, it will ask you or your representative to make any submissions in respect to mitigation and on the potential sanction. The panel chair may also read out the substantive and relevant parts of any impact statement received from any individuals who have been affected by your conduct. The hearing panel will then adjourn again to determine the sanction to be imposed before returning to announce its decision on this in public. So, witnesses. If you think someone can give relevant evidence to support your position, you can ask them to give evidence at the hearing. Witnesses will only be permitted to appear if the panel considers it is likely they can give helpful and relevant evidence about what happened that will assist it in making its decision on whether or not the code has been breached. If a potential witness refuses to appear, you can ask the Standards Commission to require them to attend. Please contact us at least 21 days before the hearing if you want the Standards Commission to require a witness to attend. You will need to provide their name and contact details, if you have these, along with an indication as to why you consider their evidence might be relevant and helpful. The Standards Commission has produced a guidance note for witnesses and a video on what they can expect at the hearing. Both of these can be found on the Information for Witnesses page on our website. So in terms of the order of evidence from witnesses will be heard in the following order. Firstly, evidence in chief. That's when the party who has asked the witness to appear, or their representative, asks questions about the witness's recollection of what they saw, heard, or witnessed in respect of the alleged breach of the code and their circumstances around it. Secondly, cross-examination. That's when the other party, or their representative, can then ask the witness questions about the evidence they have given. Thirdly, members of the panel may then ask the witness questions. Lastly, re-examination. That's when the party who has called the witness has the opportunity to ask the witness questions on any matters arising from what they were asked during any cross-examination or by the panel. The Standards Commission asks witnesses to confirm that they will tell the truth by swearing an oath or making a solemn affirmation before giving their evidence. If you are to give evidence, you'll be asked by the panel to choose whether you wish to swear an oath or make a solemn affirmation. The oath is, I swear by Almighty God that I will tell the truth, the whole truth, and nothing but the truth. And the affirmation is, I solemnly, sincerely, and truly declare and affirm that I will tell the truth, the whole truth, and nothing but the truth. So witnesses should only be asked to provide evidence about the factual circumstances that are the subject of the complaint, such as what they saw, heard, or understood to have happened, or how any events may have affected them. They should not be asked to give their opinions or views on whether there has been a breach of the code. The panel may decline to hear evidence which is not directly relevant and material to the question of whether there has been a breach of the code. The panel chair may, therefore, intervene and prevent a witness from answering a question if the panel is of the view that their answer will not be relevant. You should not put leading questions, which are questions that invite a particular response, to a witness unless they are on introductory matters. The panel may choose to disregard any evidence elicited from a leading question. Neither you nor the ESC or any representatives will be allowed to badger a witness, for example, by asking argumentative or sarcastic questions, deliberately antagonising them, asking insulting questions in an attempt to provoke an emotional response, or asking repetitive questions or a variation of a question over and over. The panel will ask any party doing so to stop and may prevent them from asking any further questions of the witness. Witnesses are not allowed to be in the hearing room until after they have given evidence. Witnesses will be provided with a copy of the numbered productions when they are giving evidence. Witnesses, including you if you are giving evidence, are not allowed access to any other paperwork or notes while giving evidence. You can, however, refer to your own notes or paperwork while making any submissions. The hearing panel may refuse to hear any evidence that it does not consider to be relevant to the question of whether there has been a breach of the Code of Conduct. Guidance on the relevancy of evidence can be downloaded from the Respondents information page on the website. In order to be relevant to the question of whether or not there has been a breach of the Code, any evidence presented by the parties and witnesses or submissions made must have a close and logical link to the conduct that is alleged to amount to a breach of the Code and any facts concerning this that are in dispute. Examples of evidence that may be excluded as irrelevant are evidence relating to the complainer's motives and evidence relating to someone else's conduct which does not form part of the alleged contravention of the Code being considered. You are entitled to both give evidence and make submissions, unless you are represented, in which case it will be for your representative to make submissions on your behalf. If you decide to give evidence, you'll be asked to take an oath or make an affirmation just like any other witness. If the hearing is being held in person, you'll be asked to sit at the witness table while giving evidence. Witnesses should give evidence about what they saw, heard, did, or understood to have happened. They should not give their views or present any arguments, as these are considered to be submissions. If you are giving evidence, you should listen carefully to each question and try to answer it as clearly as you can. Some answers will be a simple yes or no. Other questions will need you to provide more of an explanation. You should answer any questions honestly and accurately to the best of your recollection. Do not guess. If you don't know the answer to a question, you should just say so. If you don't understand a question, you should ask for it to be repeated or clarified. You should make sure that the panel can hear your answers. You should give evidence about what you witnessed, again, what you did, saw, heard, or understood to have happened. You should not be asked or attempt to give your opinion or views as to whether you consider a breach of the Code has occurred. You can address these matters in your submissions. Once you've completed your evidence, the panel chair will confirm that you're able to step down from the witness table and return to your seat. So submissions. Submissions are observations, arguments and comments about whether or not there has been a breach of the code. These can include arguments about how the code should be interpreted. You can refer to the evidence that has been given when you make your submissions, but you cannot give evidence yourself when you're making a submission. You can only give evidence if you are under oath or have made an affirmation as a witness. So other matters to note. Firstly, the Standards Commission holds its hearings in public, meaning members of the public and press can attend and observe if it is held in person. In-person hearings are usually held at the headquarters of the council or public body of which you are a member. If a hearing is held online, it will be live streamed on the Standards Commission's website. The standard of proof to be applied by a hearing panel is the balance of probabilities. This means that the hearing panel will consider whether it is satisfied from the evidence and submissions before it that a breach of the code is more likely than not to have occurred. A press release summarising the panel's decision will be issued at the conclusion of the hearing and will then be published on the Standards Commission's website. The panel's full written decision will be sent to you and published on the website within 21 days of the conclusion of the hearing. A copy will also be sent to your council or public body for consideration. If you have any questions on the hearing process, please contact the Standards Commission by email or telephone. Thank you.